This is breaking news coming in right now. A stunning decision from the United States Supreme Court has just shaken global trade politics, wiped out a major pillar of President Donald Trump's tariff strategy, and triggered what economists are calling a potential $175 billion legal storm for the United States government. If you want clear explanations of the biggest global political stories, make sure you subscribe to the channel and stay with us, because what unfolded today could reshape North American trade for years. Early this morning, Chief Justice John Roberts read a ruling that may go down as one of the most consequential trade decisions in modern American history. In a 6-3 decision, the Supreme Court ruled that the law known as the International Emergency Economic Powers Act does not allow a president to impose tariffs on foreign imports. That single legal interpretation instantly dismantled a large part of the tariff system that President Donald Trump had used for more than a year to pressure trading partners, including Canada, Mexico, and China. The ruling was blunt and direct. According to the majority opinion written by Roberts, the word regulate in the law does not give the president the authority to tax imported goods through tariffs. In other words, the court concluded that the White House stretched the law far beyond its legal meaning. 6 justices agreed with that interpretation. 3 justices dissented. But the key point here is that the ruling cannot be appealed. The Supreme Court has spoken, and the legal pathway that allowed those tariffs has now been closed. Within hours of that decision being released, officials in Canada quietly confirmed something that immediately caught the attention of economists and financial analysts. According to calculations from the Wharton School of the University of Pennsylvania, the United States Treasury could now face roughly $175 billion in potential refund exposure. That number represents tariffs that were collected under the Emergency Powers Law. Businesses that paid those tariffs can now pursue legal claims to recover the money. This means the issue is no longer just a trade dispute between governments. It has now turned into a massive legal and financial problem that could ripple through American courts and global markets. What makes this moment even more extraordinary is that 2 of the justices who voted against the tariff authority were appointed by Donald Trump himself. In effect, members of the court chosen during his presidency helped dismantle the legal structure that supported his own trade strategy. To understand the full impact, it is important to break down exactly what the court decision eliminated and what it did not touch. First, the tariffs tied to what the White House called a fentanyl emergency have effectively been erased. The administration had imposed 25% tariffs on Canada and Mexico using the Emergency Powers Law, arguing that border security and drug trafficking justified the action. Canada repeatedly argued that the justification did not match the facts. Officials in Ottawa pointed out that Canadian fentanyl seizures represent a tiny fraction of total seizures in the United States. The Supreme Court did not weigh the drug argument directly. Instead, it ruled that the law itself simply does not allow tariffs at all. That legal interpretation instantly invalidated those measures. Second, the so-called reciprocal tariffs that targeted multiple countries around the world have also collapsed. Those tariffs were designed as a global pressure strategy meant to match or punish trade barriers imposed by other nations. Because those tariffs were also based on the same emergency law, they are now legally vulnerable. Companies that paid them are expected to begin filing refund claims in large numbers. However, not every tariff has disappeared. There is a crucial detail that many headlines initially overlooked. The Supreme Court did not touch tariffs imposed under a completely different law, known as the Trade Expansion Act of 1962. Under Section 232 of that law, a president can restrict imports that are considered a threat to national security. Those tariffs remain in place today. That means the 25% tariffs on Canadian steel, the 10% tariffs on aluminum, and the tariffs affecting automobiles and lumber exports are still active. For Canada, that distinction matters enormously. Canadian steel and aluminum exports to the United States represent tens of billions of dollars in trade every year. Companies in those sectors are still paying significant costs because those tariffs survived the court ruling. But the legal earthquake created by the decision forced an immediate response inside the White House. Within hours, the administration moved to introduce a new measure using another law known as the Trade Act of 1974. Under Section 122, the president announced a temporary 10% global import surcharge designed to replace the tariffs that had just been struck down. The measure is intended to last up to 150 days, but there is an important twist. Goods traded under the North American Trade Agreement, known as United States-Mexico-Canada Agreement, were exempted from the new surcharge. That exemption appears to be strategic. By shielding North American trade from the replacement tariff, the administration avoids pushing Canada and Mexico out of the agreement just months before its scheduled review deadline. Even so, the new tariff strategy is already facing legal resistance. On the very same day the surcharge was announced, attorneys general from 24 American states filed a lawsuit challenging the move. Their argument is that Section 122 can only be used during a genuine balance of payments crisis, and they say no such crisis currently exists. Legal experts believe the case could succeed, which means the replacement tariffs could collapse just like the earlier ones. While Washington scrambled to respond, officials in Ottawa were quietly activating a strategy they had prepared in advance. According to diplomatic sources, the government of Canadian Prime Minister Mark Carney had been closely monitoring the Supreme Court case for months. Analysts inside Canada's Trade Ministry believed there was a real chance the court would reject the tariff authority. When the ruling arrived, the response in Ottawa was not celebratory, it was calculated. Canada's Trade Minister Dominic LeBlanc issued a carefully worded statement, saying the decision reinforced Canada's position that the tariffs had been unjustified from the beginning. The language was deliberate. Every dollar collected under the emergency tariff system may now become the subject of legal claims. Meanwhile, Canadian political leaders across the spectrum acknowledged that the ruling is only a partial victory. Conservative leader Pierre Poilievre noted that steel, aluminum and auto tariffs remain in place and continue to harm Canadian industries. That means the legal fight may be shifting into a new phase rather than ending completely. Behind the scenes, trade officials from both countries have already resumed high-level talks. Just days before the ruling, LeBlanc met in Washington with United States Trade Representative Jamieson Greer for the first major trade meeting between the two countries in months. The discussions had been frozen since last year during escalating tariff disputes. Both sides described the meeting as constructive, and they agreed to continue negotiations soon. Financial markets reacted quickly to the Supreme Court decision. The Canadian dollar strengthened shortly after the news broke, reflecting investor confidence that trade tensions might ease. Meanwhile, sectors tied to metals and industrial materials in the United States saw market volatility as investors reconsidered the future of American trade policy. Economists say the deeper impact is psychological as much as financial. For more than a year, the White House had operated under the assumption that emergency economic powers gave the president sweeping authority to impose tariffs almost without limits. The Supreme Court ruling shattered that assumption in a single morning. Inside Washington, officials reportedly held urgent meetings to determine what options remained. The surviving tools include Section 232 national security tariffs and other slower trade mechanisms, but the broad emergency power that once allowed rapid tariff escalation is now gone. That shift changes the balance of leverage in negotiations with trading partners, especially Canada and Mexico, just months before the scheduled review of the North American Trade Agreement. And that is why analysts are now watching several critical developments. First, whether the lawsuit against the new surcharge will succeed in federal court. Second, whether major automakers or manufacturers begin shifting supply chains because of the tariffs that remain in place. And third, whether Canada formally pursues financial recovery tied to the tariffs that have now been ruled illegal. If those refund claims begin moving through American courts, the legal and financial consequences could expand dramatically. For now, the message from the Supreme Court ruling is clear. A central pillar of the administration's tariff strategy has been dismantled. Billions of dollars in trade policy have been thrown into uncertainty. And with the North American Trade Agreement approaching a major review deadline, the United States may soon find itself negotiating without one of its most powerful economic tools.